contracts governed by the Indian Contract Act of 1872 serve as the backbone of legal transactions, defining the rights and obligations of parties involved in various agreements. Essential to the validity of a contract is the principle of acceptance, wherein both parties communicate their consent to the terms outlined in the agreement. Section 10 of the Act mandates that for a contract to be legally enforceable, acceptance must be properly communicated by all parties involved. However, questions arise when acceptance is made by an unauthorized individual. This raises the crucial query: does acceptance by an unauthorized party render the contract void, or does it still hold legal validity? Moreover, Section 2 of the Indian Contract Act provides essential definitions that shape the interpretation and application of contract law. This section elucidates key terms such as offer and acceptance, laying the groundwork for understanding the formation of contracts and the obligations inherent therein. In exploring this issue, it becomes imperative to delve into the intricacies of contract law and understand the nuances surrounding acceptance and communication within the framework of contractual agreements. Let us present to you the case of Powell versus Lee from 1908, decided by the King's Bench Division. The concept of communication of acceptance in contract law is very well laid down in the judgment of the Powell versus Lee case. The courtroom is bustling with activity as the plaintiff, Mr. Powell, sits anxiously with his lawyer, while representatives of the school board, the defendants, prepare to defend their case. The judge enters the courtroom, subsiding the murmurs, ready to begin with the proceedings for the day.
The court is now in session for the case of Mr. Powell versus the School Board Council. Please proceed with your opening statements.
The council seeks permission to approach the dais.
Granted.
The council is here in the matter of Powell versus Lee on behalf of the plaintiff, that is Mr. Powell. With due permission of the bench, the council would like to brief the bench with the facts of the case.
Granted.
Your Honor, in the case of Mr. Powell versus Lee, the plaintiff, Mr. Powell, was a candidate vying for the position of headmaster at a school. The managerial authorities referred his candidacy to the appointing authority, which subsequently released a resolution indicating his appointment. However, crucially, this resolution was not directly conveyed to Mr. Powell. Instead, it remained an internal decision at that point. It was only when one of the board members informed him of the meeting's decision of his appointment to Mr. Powell that he was aware. Understandably, Mr. Powell, upon receiving this information, believed himself to be appointed and looked forward to assuming the responsibilities of the headmaster position. Regrettably, the members of the board later revised their decision, effectively rescinding the resolution that initially appointed Mr. Powell. We contend that the school board's actions constitute a clear breach of contract, and we seek appropriate redress for our client.
The council seeks permission to approach the dais.
Granted.
May the council begin, Your Honor?
Yes.
Your Honor, while it is regrettable that Mr. Pal received incorrect information regarding the employment status, it is crucial to recognize that the defendants cannot be held liable for a breach of contract. In the realm of contract law, the fundamental principle dictates that acceptance of an offer is only valid when it has been formally communicated to the offering party by the party accepting the offer. This communication serves as a clear indication of the acceptance and ensures mutual understanding and agreement between the contracting parties. In the present case, it is evident that the managers did not formally communicate the acceptance of Mr. Powell's candidacy to him. Although a board member, that is Mr. Lee, informally relayed the decision to Mr. Powell, this communication lacked the official authorization and formal notification typically required in contractual agreements. It was a leak of information, which Mr. Lee and the board regrets. The absence of such formal communication indicates that the managers intended to reserve the power to reconsider the decision at their discretion. Furthermore, it is essential to emphasize that awareness of acceptance through a third party does not suffice to fulfill the legal requirement of communication. And in this case, there was no acceptance as such. The integrity and clarity of contractual agreements hinge upon direct and explicit communication between the contracting parties formally, ensuring mutual assent and understanding of the terms. I urge the Honorable Court to uphold the principles of contract law and dismiss the plaintiff's claim of breach of contract against the defendant.
Let's proceed with the presentation of evidence. Approach.
The plaintiff and the defendant party submit evidences in the form of testimonies by Mr. Powell and the school board members. The evidences also had the minutes of the meetings along with Mr. Powell's application for the position of headmaster. The judge carefully examines the given evidences before proceeding further.
Let's proceed with cross-examination. Plaintiff's attorney, please begin.
The prosecution would now like to call upon the first witness, prosecution witness 1, Mr. Powell, for the cross-examination.
Granted.
Mr. Powell, when you were informed by the school manager that you had been accepted for the position of headmaster, did you or did you not believe it to be a binding agreement?
Yes, I did. I had no reason to doubt the authenticity of the acceptance as it came from a member of the school board itself.
Thank you, Mr. Powell.
Your Lordship, may it so please the court that the counsel on behalf of the defendants as their legal representative would like to commence the cross-examination of prosecutor witness 1.
Yes.
Much obliged. Mr. Powell, can you confirm that the individual who conveyed the acceptance to you was not acting in their official capacity as a representative of the school board?
Yes, that's correct. They were acting on their own accord and not as a representative of the school board, but I did believe that.
Thank you. Now, Mr. Powell, did you receive any written confirmation of your appointment?
No, I didn't receive any written confirmation of my appointment.
Mr. Powell, can you attest to the fact that you did not receive any official communication of the acceptance from the school board?
Yes, I never received any official communication regarding the acceptance of my application.
Thank you, Mr. Powell.
After analyzing the situation with the given facts, evidences, and cross-examination, the court is now ready for a round of rebuttals.
Your Honor, the learned counsel has vehemently argued against our client, but for the better understanding of the court, the plaintiffs request certain clarifications from the respondent's counsel. Your Honor, the key issue in this case is whether a valid contract was formed when Mr. Powell was informed that he had been accepted for the position of headmaster. We argue that there was a clear acceptance made by the school manager, Mr. Lee, which Mr. Powell accepted by preparing for the role. This created a binding contract and the defendants are liable for breaching it.
Your Honor, the statement made to Mr. Powell was merely an expression of intent and not a formal acceptance by the school board of the offer of employment originally made by Mr. Powell. Without the proper authority, the school manager could not bind the defendants to a contract. Therefore, no contract was formed in the first place and the defendants cannot be held liable for breach.
Your Honor, the evidence submitted provides the minutes of the meeting before Mr. Lee conveyed the acceptance to Mr. Powell. Here, we see how in the meeting it was concluded that Mr. Powell will be the one given the position of the headmaster, which means they accepted his offer. Later, through Mr. Lee, Mr. Powell gets the knowledge of the acceptance. As we understand from basic philosophy of contract law, the communication of acceptance is completed as against the proposer when the acceptance is in transmission and out of the power of the acceptor, which in this case is represented by Mr. Lee's communication, whereas the proposer, which here is represented by Mr. Powell, coming to the knowledge of his acceptance through Mr. Lee. Hence, we can conclude that through Mr. Lee's communication, both the parties became bound to the contract as well as essentials of acceptance and communications of acceptance were fulfilled.
Your Honor, these arguments based on communication of acceptance are completely baseless, as in the next minute's meetings as submitted, we can evidently see that it was decided that Mr. Powell will not be given the position and such a letter of rejection was sent to him after this final decision, which means that the discussion on Mr. Powell's candidacy was in process. It would be completely wrong to infer that informal information of discussions and decisions made inside a board before the final and official decision, which are conveyed only through formal means, in this case a letter, can be regarded as a legitimate acceptance or even rejection. These final decisions are a product of meticulous debates amongst the members, and they can be overturned any time before the official announcement is made. It is within the rights of a board to make as well as undo these decisions. Hence, we cannot refer to the disclosing of such discussions in personal capacity of any member as acceptance.
Let us proceed with closing arguments.
The council would like to seek permission from the bench to present its closing statements.
Granted.
Your Honor, it is very clear that Mr. Powell was informed by the school manager that he had been accepted for the position of headmaster. Mr. Powell believed this to be a binding agreement and made preparations accordingly. The defendant's failure to honor this agreement has caused Mr. Powell significant damages, and we urge the court to find in his favor.
The council would like to seek permission from the bench to present its closing arguments.
Granted.
Much obliged. Your Honor, while we sympathize with Mr. Powell's situation, the evidence does not support his claim of breach of contract. The statement made to Mr. Powell lacked the necessary authority and intention to create a legal relationship, and it was in an informal setting, out of the authority of being a board member. It was in Mr. Lee's personal capacity, while the matter at hand is of formal nature. Without a valid contract in place, as the facts do not support the most imperative essential of a contract, that is, the acceptance, the defendants cannot be held liable for the breach. We urge the court to dismiss Mr. Powell's claim. Thank you.
Having considered the evidence and judgments presented by both parties, the court finds that the statement made by Mr. Powell regarding his acceptance for the position of headmaster lacked the necessary authority and intention to create legal relations. Therefore, no contract was formed and the defendants cannot be held liable for breach. The court hereby dismisses Mr. Powell's claim. This concludes today's proceedings. The court is adjourned.
This is Deyona Shajees. I will expand on the facts of the case. To summarize once again, Mr. Powell, the plaintiff, applied an application to a school for the position of headmaster. The school board accepted his application and thereby decided to appoint him. However, before such a decision of appointment was conveyed to him by the authorized authority, one of the board members acting in his capacity informed the plaintiff of the board's decision. Later, for some reason, the council changed their mind and decided to withdraw their decision by appointing someone else. Agreed by this, the plaintiff, on the grounds of breach of contract, filed a suit against the school. Now, let us expand on the issues of the case. The main contention that came to the court was whether there was an actual breach of contract by the school or not as stated by the plaintiff. Now, what was the judgment of the case? The court carefully considered the arguments presented and concluded that there was no breach of contract. Initially, there existed no contract between the plaintiff and the appointment authorities. The court emphasized that the informal communication from a member of the authority did not constitute proper acceptance by the school board. It was further noted that for a valid acceptance to occur, there must be communication of an authorized representative of the authority. In this case, the informal communication failed to meet this requirement, rendering the purported acceptance invalid. Consequently, no binding contract was formed between the plaintiff and the school board. Therefore, the court held that since the acceptance of the application was not communicated by an authorized authority, there existed no contract between the plaintiff and the school board. Consequently, the concept of breach of contract did not arise. Now, let's analyze the law according to Indian Contract Act 1872. The case exemplifies the pivotal role of valid acceptance and communication in contract law as per the Indian Contract Act 1872. It underscores that for a contract to be enforceable, acceptance must be communicated by the offeree or an authorized representative. Here, the unauthorized communication of acceptance by a member of the school board acting beyond his authority rendered the purported contract invalid. Despite the board's initial decision to appoint the plaintiff, the lack of proper communication by an authorized party nullified any contractual obligation. Consequently, the plaintiff's claim of breach of contract was dismissed, highlighting the legal principle that contracts entered into by unauthorized individuals lack enforceability. This case reinforces the necessity of adherence to legal principles in contract formation, emphasizing the importance of proper communication and authorization to establish valid and enforceable contracts. In the Indian context, the laws applicable to the case would include Section 2A of Indian Contract Act 1872, Section 2B of the Indian Contract Act 1872, Section 3(4) of the Indian Contract Act 1872, Section 7 and Section 10 of the Indian Contract Act of 1872. According to the Indian Contract Act 1872, Section 2A states, when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Now let us analyze the rationale behind Section 2A. The rationale of Section 2A lies in its essentials. This rationale is that an offer can only be made by a person, natural or artificial. There should be at least two parties involved, as one cannot make an agreement with himself. Next, the word signifies represents the communication of the offer to person it is being made. No one can claim an offer has been made if it never reached the other party it was intended towards. Further, there should be a willingness to do or abstain from doing anything, that is, the genuine desire to do or not to do something which forms a core of an agreement, as this is the duty or responsibility that the offerer will take upon himself. Lastly, an intention to create a legal relationship and enter into an agreement with the assent of the other party is required, so it can be legally binding. Now let us check the relevance of the case. Herein, Mr. Powell made an application to the school board authority for the vacant position of headmaster. This application fulfills all the essentials of a proposal, as Mr. Powell signified his willingness to work as the headmaster and through his application wanted to receive the assent of the school board.
Section 2B states, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal when accepted becomes a promise. Rationale. The rationale of Section 2B outlines the reasoning behind the principle that only the individual to whom the offer is extended can truly accept it by communicating their assent to the offerer. Acceptance cannot be delegated to another individual, nor can it be assumed based solely on mental acknowledgement. For acceptance to be valid, it must be effectively communicated by the intended recipient of the offer.
Section 3 talks about communication, acceptance, and revocation of proposals. The communication of proposals, the acceptance of proposals, and the revocation of proposals and acceptances, respectively, are deemed to be made by any act or omission of party proposing, accepting, or revoking by which he intends to communicate such proposal, acceptance, or revocation, or which has the effect of communicating it. Rationale. Section 3 has stated that only the parties accepting, proposing, or revoking can communicate their acceptance, proposal, and revocation through their act or omission. This means that any third party acting on the record will not be considered as valid communication as the above. Relevance. Here, it was decided that only the formal communication through an official letter by the school board will be regarded as the communication of acceptance or revocation. Thus, official rejection letter sent to Mr. Powell was valid, where the unofficial and informal statements made by Mr. Lee are not valid communication. Section 4 talks about when the communication of a proposal, acceptance, and revocation may be complete. Rationale. Section 4 underscores the necessity for agreements to hold binding power over the involved parties, thereby imposing upon them the legal obligation to fulfill their respective duties as outlined within the agreement.
Relevance. In the case of Powell versus Lee, it was decided that the communication of acceptance was not valid as no acceptance was sent formally in the first place. Hence, the parties were not bound in any contract. Additionally, the communication of revocation of a proposal, which here refers to the formal rejection of Mr. Powell's application, fulfilled all essentials of communication of revocation and hence was deemed valid. Section 10 states that all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. Rationale. Section 10 is implemented with the explicit purpose of eliminating any agreements that fail to meet the fundamental requirements of a contract, rendering them enforceable by law. It emphasizes that only agreements meeting the legal criteria can attain the status of contracts, and consequently, only disputes concerning such contracts will be entertained by the court. This provision underscores the importance by ensuring that agreements adhere to the legal framework to be recognized and upheld by the judicial system. Relevance. Let us analyze if the contract as claimed by Mr. Powell fulfills the essentials of a contract according to the Indian Contract Act of 1872. The first essential is free consent. Both parties, Mr. Powell and the school board, had entered into agreement of Mr. Powell contesting for the headmaster's post with free consent but not for his acceptance. The second essential is competency. Yes, all parties involved on the board as well as Mr. Powell are competent to form a contract. The third essential is lawful consideration and lawful object. The proposal had both lawful consideration and object in the form of Mr. Powell's services as a headmaster and his salary. The fourth essential is not expressly declared void, which is again fulfilled by agreement, as an agreement regarding the position of a headmaster of the school is not void by any law or provisions of any law. It is also not defeating the purpose of object or any law. Section 7 Clause 1 states that acceptance must be absolute and unqualified. Here it was decided that acceptance was not made in the first place. Section 7 Clause 2 states the conditions for acceptance to be expressed for entering into a contract. We observe that the court decided that the informal communication of acceptance by Mr. Lee in his personal capacity did not qualify as a reasonable manner. Rationale. Section 7 is established on the principle that acceptance must be unequivocal and cannot be fragmented or subject to additional conditions beyond the original offer. It necessitates the acceptance be whole without any reservations, ensuring clarity and mutual understanding between the parties involved.
In conclusion, the Indian Contract Act of 1872 provides a comprehensive legal framework that addresses the intricacies of contract formation and enforcement. Through its provisions, the Act ensures clarity, fairness, and enforceability in contractual agreements, promoting trust and confidence in commercial transactions. The case of Powell versus Lee serves as a pertinent illustration of how adherence to legal principles in contract formation is essential for upholding the integrity of contractual relationships and resolving disputes effectively.